system, and we're talking to the district judge for the Middle Tennessee District, Judge William J. Haynes. And of course, Judge Haynes, before we had our first commercial break, we indicated that we wanted you to talk about some additional things in reference to being a district judge in a real sense, and some of the things that many people might not be familiar with, and so that we can use this primarily as a teaching tool, and that's what we are concerned about this morning. Let's talk about judicial appointments. I think that all of us are familiar with these appointments being made by the president or somebody else, and et cetera, and we really don't understand the steps that are involved in it. So why don't you just sort of take us through some of the judicial appointments that that you think that we ought to be familiar with, some of the efforts in terms of making a judicial appointment.
Well, judicial appointments under the Constitution is reserved, is really an interreaction between the executive branch and the legislative branch. The Founding Fathers determined that for this branch of government that they would have an interdependence of political power. That is expressed in that the president has the authority under the Constitution to nominate judges for lifetime tenure, because with lifetime tenure it is a significant appointment. However, the Founding Fathers concluded that the United States Senate would have the authority to confirm nominees, to give advice and consent on whether this person should have a lifetime tenure. Because once you are vested in that office, you have life tenure, and you have the authority to, in fact, affect people's lives. And so the process involves a dual exercise of authority under the Constitution. As a practical matter, the appointment process may differ. For district judges, traditionally, if the president may consult with the senators of the state, who would sometimes set up commissions or otherwise identify persons that they would recommend to the president for nomination. Whether the senators or the president are of the same political party may have an impact on that. My experience in Tennessee is that there's been an excellent relationships and a bipartisan approach on the confirmation of federal judges. And so even though the president may be of one party and the senators of another party, there's been, in my experience, excellent cooperation. I was recommended by Vice President Gore, as I mentioned, but I had the enthusiastic support of Senator Frist and Senator Thompson that was a part of the Senate confirmation process. For the Court of Appeals, that may vary according to the president. The president may defer, again, to the senators, but because courts of appeals hear matters beyond one single state. For example, I mentioned to you the Sixth Circuit hears appeals from Tennessee, Kentucky, Ohio, and Michigan. So the president may feel that the executive branch should have more of a say in who the nominee should be, although because there is the advice and consent function, the senators will, in the process, will be consulted on whoever the person is being considered for the nomination. For the Supreme Court, of course, that's a national appointment, and it involves policy making